Hello and welcome. Permit me to take this opportunity to congratulate each of you as you begin in your newly elected role as executive officers of the General Employees Association of Trinidad and Tobago. As you embark on this new journey, permit me to share with you some valuable insights regarding collective bargaining. In my presentation with you, I will be addressing 4 areas. 1, ILO conventions relative to collective bargaining. 2, strategies such as fostering, and the combination of both. 3, objective criteria and negotiating team preparation. 4, the grievance procedure in contract administration. So now I'm going to discuss with you the significance of relevant ILO conventions in the context of collective bargaining. Now, there are several key ILO conventions that are pertinent to collective bargaining. In the essence of time, I'm only going to go through 3 of those conventions with you. The first is Freedom of Association and Protection of the Right to Organize Convention, and this comes from number 87. This convention establishes the right of workers and employers to form and join organizations of their own choosing without interference from the state or employers. It also protects against discrimination based on union membership. 2, the right to organize and collective bargaining convention. And that convention is number 98, and it also complements convention number 87, which we spoke of previously. The right to organize and collective bargaining ensures that workers have the right to engage in collective bargaining with employers through their chosen representative. It mandates that measures be taken to promote collective bargaining and prevent interference by employers in the bargaining process. 3, tripartite consultations, and this comes from Convention number 144. This convention emphasizes the importance of consulting with employers and worker organizations when implementing international labor standards at the national level. It encourages dialogue and cooperation between governments, employers, and employees to ensure effective implementation of international labor laws. And remaining on the ILO conventions, but this time we're going to look at how it is pertinent to the association's objective. And when I speak of association, I am making reference to you. It's the General Employees Association of Trinidad and Tobago. To identify and explain the key conventions that are pertinent to the association's objectives, it is important to identify what the association's objectives are. On the website, they implied the main objective is to provide uncompromising support and assistance to their members in an effort to protect their general welfare and employment status. And because we're under the same topic of collective bargaining, quite a few of the conventions that we spoke of earlier will also apply to the association. So at this time, I'm just going to mention what they are. I selected 5 of the most critical ones. 1, the freedom of association and protection of the right to organize. And this is ILO Convention number 87. 2, right to organize and collective bargaining. And this is ILO Convention number 98. 3, non-discrimination, employment and occupation convention. And this is ILO Convention number 111. And basically, this convention speaks about prohibiting discrimination. All right? And these are the classes that we look at when we speak about prohibiting discrimination. We look at race, color, sex, religion, political opinion, and national extraction or social origin. There's more, but as I said, in the essence of time, we're only going to highlight the main ones. 4, minimum wage fixing convention. And this is ILO Convention number 131. This deals with the principles for setting minimum wages. And the aim is to ensure that workers receive remuneration that is sufficient to provide for their basic needs and maintain a decent standard of living. 5, very critical, occupational safety and health. And this comes from ILO Convention number 155. This convention sets out the principles and measures to ensure the safety and health of workers in the workplace. And now we're going to move on to a second objective, which focuses on strategies. And again, these strategies are forcing, fostering, and the combination of forcing and fostering. As you may be aware, in collective bargaining, both unions and employers use different strategies to achieve their desired outcomes. These strategies include forcing and fostering. In essence, forcing is used to push agendas forward, while fostering focuses on building relationships and cooperation. In their texts, Walton, Gershenfield, and McCarthy describes forcing as a strategy employed by one party to impose its will on the other party through various means. Forcing in negotiations entails one party trying to achieve its goals by exerting pressure on the other party. And this is usually done through strikes, lockouts, or utilizing economic and political leverage. Fostering, on the other hand, involves open communication and collaboration. This is where both parties work together to find solutions that are mutually beneficial. It prioritizes building trust and understanding, creating a positive atmosphere for resolving conflicts and reaching agreements that satisfy both sides. So in essence, fostering is aimed at creating that win-win situation. Both strategies, forcing and fostering, can be used solely, or they can be combined to achieve the desirable results. At this moment, I direct your attention to the screen to observe these strategies. Remaining on the topic of forcing, fostering, and combination, now we'll examine when to use each strategy and why use each strategy. Again, I'm going to direct your attention to the screen where you will observe each strategy. Kindly note that this data is taken from Fisher, Roger, Urey, and Patton getting to yes. Now we move to our third objective, which is focused on objective criteria during negotiations. Objective criteria in negotiations helps shift the focus from arguing to problem solving. Both sides work together to find fair solutions that make sense for everyone. This makes negotiations more transparent, fair, and efficient. As a result, the agreements reached are based on logical reasoning rather than personal preferences or unfair demands, making them more likely to stand the test of times. In their study, Stitfield Handy Group and Professor E. Wortham outlines that objective criteria helps ensure fairness, promotes mutual agreement, and reduces conflicts. It provides a neutral basis for decision-making, making it easier for both parties to reach a consensus without relying on subjective opinions or emotions. This approach enhances trust, it facilitates smoother negotiations, and it increases the likelihood of a lasting and satisfactory agreement for all involved. Let us review a few pointers regarding the importance of utilizing objective criteria, and this comes from Walton, Gershenfield, and McCurse's text, A Behavioral Theory of Labor Negotiations. 1. Depersonalization of negotiations. Objective criteria depersonalizes negotiations by shifting the focus away from individual interests, personalities, or power dynamics. Instead, negotiators rely on external standards such as market rates, industry practices, or legal precedents. 2. Reduction of power dynamics. When both sides follow objective criteria, it's like playing by the same rules. This makes negotiations more balanced and encourages cooperation. 3. Promotion of rational analysis. Using objective criteria means decisions rely on facts, not opinions. 4. Enhancement of agreement durability. Agreements based on objective criteria last longer because they are fair and widely accepted. When everyone agrees to the rules, there's less chance of arguing or disagreeing later on. 5. Facilitation of principled negotiation. The use of objective criteria aligns with principles of principled negotiations. Now, principled negotiation emphasizes separating people from the problem. And now we're going to discuss the role of thorough preparation by the negotiating team in achieving favorable outcomes. In Walton and McCarthy's text, they stated that thorough preparation by the negotiating team is emphasized as a critical factor in achieving favorable outcomes. So, at this time, I'm going to give you some pointers in terms of how thorough preparation plays that critical approach. 1, understanding interest and position. So you have to understand the interest behind both parties' position. All right? Anticipating alternatives and banters. All right? Again, you have to understand each party's banter, allowing negotiators to evaluate their relative strength of their position and to determine their bargaining leverage. 3, gathering relevant information. Having accurate and up-to-date information allow negotiators to make informed decisions. 4, developing negotiation strategies. By anticipating potential scenarios and planning responses in advance, negotiators can react quickly and strategically during negotiations, increasing their ability to influence outcomes. 5, building trust and credibility. Building credibility and trust is essential for fostering constructive dialogue, promoting cooperation, and reaching mutually beneficial agreements. At this time, I'm going to provide some examples of objective criteria. 1, market research. Before negotiating a salary rise, objective criteria might include data or industry standards and average salaries for similar roles in the region. 2, legal precedents. In contract negotiations, objective criteria could be past legal cases or precedents relevant to the terms being discussed. 3, performance metrics. When negotiating performance incentives, objectives criteria may include specific measurable performance metrics agreed upon in advance. Example, sales targets. 4, economic indicators. In price negotiations, objective criteria might include economic indicators like inflation rates. 5, expert opinions. Objective criteria can also include expert opinions or assessments from third-party consultants in areas such as property valuations. And now we're going to look at effective negotiation preparation techniques. 1, you want to define objectives. Clearly outline negotiating goals, including desired outcomes and acceptable concessions to guide the negotiation process effectively. 2, conduct research. Gather comprehensive information about the other party's interests, preferences, and constraints to acquire their positions and prepare persuasive arguments. 3, understand the interests. You must be able to distinguish between positions and interests, as indicated earlier. 4, develop banters. Best alternative to a negotiated agreement. 5, plan strategies. Develop negotiating strategies tailored to the specific context. 6, build a rapport. Establish rapport and trust with the other party through active listening empathy, respect, and active communication. 7. Generate options. Brainstorm creative solutions and alternatives that address both parties' interests. 7. Prepare for concessions. Anticipate potential concession trade offs. 9. Practice flexibility. Remain flexible and adaptable during negotiations. 10. Review and reflect. After negotiations, reflect on the process and outcomes to identify lessons learned and areas of improvement for future negotiations. And finally, our fourth objective for the day, grievance procedure in contract administration. So first, we're going to look at the steps or the procedures for grievance in reference to contract administration. I have highlighted same for you on the screen. So again, I ask you to direct your attention where we're going to go through them briefly.
The grievance procedure is structured into 4 distinct steps. Each step provides detailed guidelines on the necessary actions to be taken and identifies the involved parties.
All right, so now we're going to discuss the significance of having a clear and effective grievance process for resolving disputes. A clear and effective grievance process is essential for resolving disputes because it offers a structured approach to addressing concerns. It ensures fairness, transparency, and timely resolution, preventing conflicts from worsening. This process also fosters trust, it boosts morale, and promotes positive relationships within the organization by demonstrating a commitment to addressing issues promptly and fairly. As outlined in Terry Lip's collective bargaining and labor relations text, having a clear and effective grievance process is significant for several reasons. And at this time, we're going to go through briefly 6 of those reasons. 1, fairness and transparency. 2, conflict resolution. 3, employee satisfaction and morale. 4, legal compliance. 5, improvement to policies and procedures. 6, preservation of labor relations. Now, we're going to look at some of the best practices for implementing and managing the grievance procedure. 1, you want to ensure that you have a clear policy and procedure, and that should be either from the collective bargaining agreement or the employee handbook. 2, effective communication. You want to keep communication open between management, employees, and union reps about the grievance process. 3, timely resolution. Resolve grievances promptly to prevent escalation and maintain trust. 4, impartial investigation. Conduct thorough, unbiased investigations into grievances. 5, mediation and arbitration. If informal solutions fail, use mediation or arbitration. 6, documentation and record keeping. Maintain accurate records of all grievances, including documentation of the complaint in the investigation process, the outcomes. 7. Feedback and continuous improvement. Seek feedback from employees, union reps, and management on the grievance procedure for continuous improvement. 8. Training and education. Train managers, supervisors, and employees on the grievance procedure, clarifying their roles. 9. Confidentiality and privacy. Maintain confidentiality and privacy throughout the grievance process. 10. Follow-up and closure. After resolving a grievance, confirm that the agreed upon actions are taken. And you also want to ensure that you communicate the outcome to the relevant stakeholders for closure. And now I've reached the end of my presentation. Thank you.